I'll let Vic kick it off for us. All right, Vic.
Thank you all for being here. Thank you all for being here. Dr. Begum is gonna present some of her latest research with us today. We're gonna save questions towards the end. And you all already kind of seen the flyer with her bio and so forth. But folks who haven't seen it, I do have it here, so I'm gonna read it to you so you know who's in front of you. So Dr. Popy Begum is currently an assistant professor of criminology and criminal justice at St. Louis University. She completed her PhD at the School of Criminal Justice, Rutgers University, Newark campus. Popy graduated from John Jay College of Criminal Justice with a BA in International Criminal Justice. She also earned the MS in Criminology and Criminal Justice with a concentration on research methods from the University of Oxford. Her dissertation research examined the lives of Hindu and Muslim sex workers in New Delhi, India, using ethnographic field observations of the red light district and 102 in-depth interviews via respondent-driven sampling. Popy's research has also been supported and recognized by organizations locally and internationally, including the Howard League for Penal Reform, the American Society of Criminology, the Academy of Criminal Justice Sciences, the Association of Doctoral Programs in Criminology and Criminal Justice, the Association for the Sociology of Religion, Religious Research Association, and the Society for the Scientific Study of Religion. Popy's work has appeared in peer-reviewed journals, including, but not restricted to, Criminal Justice and Behavior, Trends in Organized Crime, Social Policy and Society, Victims and Offenders, the Journal of Criminal Justice, and edited volumes published by Oxford and Cambridge University presses. Without further ado, I'll turn it over to Dr. Popy Begum.
Thank you so much, Vic, for the very generous introduction. I almost feel embarrassed. And thank you all for being here. This is such a wonderful turnout. So thank you for caring about courts. So today I'll be presenting on a project that I started as a doctoral student at School of Criminal Justice. Some of you had a chance to talk about it a little briefly. It's not my primary area of interest. It's a secondary area. It was something that completed programmatic requirement, and then it kind of fell on the back burner because I was focusing on my dissertation research looking at religion and sex work. So without further ado, it's a discourse analysis of how judges open and close cases in a first appearance court in New Jersey. So first, putting first appearance court in context. So as you all may or may not be familiar, general processes of punishment in lower courts typically focus on pretrial detention. So someone gets arrested, they're held, and they need to figure out next steps for their case, whether they're going to get bail, whether they're going to be remanded, whether they're going to be released. And courts are actually open to the public. And so anyone can go. My mother, your grandmother. I don't think you bring your dog, but it's pretty open to the public. And it's obviously local, it's situated action, and it follows some form of normative order because judges more or less follow a script. And if you spend enough time in a court, you'll know what the judge is going to say next. You almost know what the outcome is going to be, and so forth. And so typically they do one way or another reflect some sentiment of society because the people that we elect, right, whether it's the prosecutor, these people are voted, right, by the people, or they're put in power by, local officials that we vote for. And what's really interesting about first appearance courts is that scholars argue that it's largely arbitrary in terms of decision making. So obviously some defendants will go to jail, others will go free, and the judge kind of gets to hear from various, courtroom actors, prosecutors, the defense, and then they make a decision. They're however lenient, right? Because most people, depending on the severity of the offense, may get remanded, right? It may go to trial, but people do also get released. Judges could also impose large fines and bail. The other important aspect of first appearance courts is that almost 80 to 90% of cases begin and end here. So this means that most people in the United States who have any kind of criminal justice contact will appear before a first appearance court and will most likely not have interaction again, right? This is excluding people who have high risks of recidivism. The caseload here is very, very heavy. So if you've ever been in a court, there's a new roster that gets printed every day. It's usually plastered on top of the outside the courtroom, and you'll have a sense of who's being seen, what are the offenses, and so forth. And so as a result of creating outcomes for everyone, we see fast deliberations, right? It's an assembly line. Everyone has a role to play. It's kind of predictable, and they're very swift. So most of these interactions are no more than 3 minutes. In the event that there is an interaction or a defendant appears before a judge that exceeds that, it's typically if perhaps a witness is not available or there needs to be a language interpreter. And that's usually what would exceed this 90-second or more, less than 3 minutes. So unlike the reading of rights, charges, conditions of release, openings and closing, interestingly, are not codified by law or policy. And that's what makes them so interesting to study because they're kind of trivial, right? But it's exactly that, the trivial aspects of interactions in the courtroom that I think have implications for fairness and the extent to which we think we're being treated fairly, regardless of what the outcome is. And so variation may occur because these changes are unscripted, right? Judges are following some kind of script, but how they open a case and how they close out the case is not something that's scripted. So they have a little bit of leniency in terms of how to do that. And the reason why we should care about this is because, again, it shapes not only justice and our ideas of fairness and justice, but it's less about the law and more about bureaucratic and administrative details. So as a result, it kind of gets lost in the process. In terms of judicial behavior and decision-making, there is a code of conduct that judges are expected to follow. So there is policy. And the policy is that judges need to be patient, dignified, and respectful and courteous to everyone. And that includes people who appear before them in the courtroom, regardless of what they have done. However, researchers describe patterns of differential treatment across extra-legal factors, right? First and foremost, race and sex, white versus non-white defendant, male versus female. So research shows that people who come from minoritized or identify with minoritized background are more likely to be treated harshly or not respectfully, right, by courtroom actors. We see similar differential treatment across males and females. So females are treated a little bit more leniently as opposed to males. And this could be somewhat shaped by ideas of dangerousness, right? Ideas of violence, ideas of the extent to which someone could be harmful. Mode of appearance is also really interesting. So people who are obviously appearing in person, or maybe it's not that obvious to non-criminologists, you obviously were able to afford bail. And that's why you're able to appear before a judge. So that signals perhaps class and capital. Whereas video, right, you're incarcerated, you're appearing remotely, and it's a proxy for you're not able to afford bail, and maybe you don't have the resources to appear physically. Type of legal representation also matters. So because I also do courtroom observations, one of the things I realize the distinction between the two is that obviously one is another marker of class, right, and resources. But procedurally, they're also different. So for example, if you have a public attorney, you don't get to have the reading of the charges waived compared to private. So when defendants appear before the court, the prosecutor, right, will read out what the charges are, right? But you can have those waived if you have a private attorney. And that's a privilege that's not available to people who have public attorneys. Use of an interpreter is also a really interesting one because it could be used as a marker for immigration or non-native. So someone who speaks English with an American accent would be treated a little bit better and fairly than, let's say, someone who's not. And then finally, patterns of differential treatment are typically linked to case outcomes, right? Sentencing outcomes, not necessarily informal processing, right? So why do some people get a good morning and others get, see you next week, or don't get any kind of closing from the judge. And as a result, this brings me to what I'm trying to study, the deployment of language by judges, right? Is it even? Is it uniform? Or is there a disparity? And if there is a disparity, what shapes that? And the reason why all this matters is because it has implications for procedural justice. So theoretically, this study is informed by procedural justice, the idea that the system is fair, it's uniform, everyone gets treated the same. And it's not necessarily consumed with outcome, right? So if you're treated fairly and nicely and you think the outcome is the same for everyone, you're more likely to think that the end outcome, whether you're going to prison or getting fined, is something that's legitimate and it's fair and it was decided upon in a just manner. So I'm interested in two questions as a result. How does language deployed by judges in first appearance courts vary in case openings and closings? And are those variations associated with defendant attributes? And so this brings me now to the methodology. So when I first started this study, I did go to court, but I was really overwhelmed because when you go to court, because these are pre-trial, cases are 1 to 3 minutes, and you're trying to capture all that detail. And it's really chaotic, it's really overwhelming, and you really feel like you're failing. So what's the next best option? Transcripts, right? Audio recordings, because you can stop it, you can think, you can probe, you can figure out what's going on here in ways that you can't do in person. So I was able to get my hands on 10 audio recordings of first appearance sessions in court that happened in 2015 and 16. So this was pre-bail reform in New Jersey that happened in 2017, where cash bail was not the only option for release. And so what I did was I faithfully transcribed one session, and I had my students do the subsequent sessions, and then we reviewed those sessions. So 2 people listened to them simultaneously to make sure that it was faithfully transcribed, just because we were working with court documents, and it's important to be able to know what we're talking about accurately. So as a result, we get to mixed analysis. So how did we do that? So what I did was first we took the transcripts, right? And we looked for key information. So date of the hearing, name of the judge, name of the defendant, gender, age, if it was provided, because usually there's turn taking by different members of the courtroom. So the bail unit will usually give you like a laundry list of things that the defendant did. He's living in Jersey City with his mother. He's unemployed. He's 28 years old. He doesn't have any ties to the community. So you get a lot of information, right, from these transcripts. We also were able to get variables, observations on the status of the defendant, whether they're in custody or out on bail, mode of defendant's appearance, court or video, the type of representation, public, private, or waiting to be assigned. Sometimes they would go before a judge and it was unclear whether they were being represented by a public or private, defender, right? Sometimes the judge would have to say, please stay behind so you can interview and see if you qualify for pretrial services, and that is a public defender. And whether an interpreter was needed. So sometimes there would be cases where it would proceed, and then middle of it, the judge will figure out the defendant doesn't speak English. And now suddenly they have to stop and figure out what language the defendant speaks, or whether that interpreter is readily available. And if it's not Spanish or like a more common language, like let's say it's Arabic or Chinese, then the case would have to be, set for another date. And then obviously conditions of bail release and reasons for remand. So what we did was we extracted all these variables and we created a database. And as I said, we had 294 cases, and that allowed for descriptives to be run, chi-square test of independence to examine the relationship between the defendant attributes like mode of appearance, whether they needed an interpreter, gender, and then the type of opening and closing, which I'm going to get at. So this brings me to the second analysis, so discourse analysis. So as those of you who are familiar with linguistics literature, there's no common or agreed upon definition in terms of what is discourse, but scholars generally agree that it could be multiple things. It could be talk, it could be text, it could be content, but as long as you're analyzing it systematically, right, it counts as discourse analysis. So here, the way I'm defining is verbal communication between judges and defendants, right? That would configure distinct patterns of treatment. And these are unprompted, meaning that's the first thing that the judge says to the defendant that's unprompted, and the last thing that the judge says to the defendant that's unprompted. Because otherwise, if there is turn taking, then the turn taking influences then the unpromptedness of or the promptedness of how the judge opened or closed the case. So we coded these transcripts with my undergraduate students. There's 2 coders per transcript, and we looked at reoccurring themes. And 80% of the time, there was intercoder reliability. And when there wasn't, we just talked it out and we try to figure out what's the common ground here. And so an opening is where a judge briefs defendants in the beginning of the case. And then there's all this stuff in between that happens, right? And then like the judge will outline the charges, the prosecutor will outline the charges, and then the defense will get a chance to respond. And then the judge will, agree what the outcome should be if there is one. And then a closing where the judge ends their interaction with each defendant. But oftentimes sometimes there are cases where there's like no closure and the judge just the law clerk calls another case. So the defendant doesn't get a proper closure. And so now I'm going to walk you through case characteristics. So full disclosure, I'm actually a qualitative scholar. This is one of the papers that kind of pushed my boundaries, where I had to learn how to read stats. And so I'm going to try to do my best. So they said we had a total of 294 cases. Most of the defendants within the transcripts, right, we would say were relatively poor because they qualified for a public defender, 77%. Very few cases, right, 27 out of 294 that required a language interpreter. Typically Spanish, but there were times where we saw defendants who needed an Arabic interpreter as well. Co-defendants, right? Not so many, almost 69 cases. And then it was largely male, but we had a pretty, I would say, close to an even sample. It was largely male, not close to an even sample. In terms of mode of appearance, many of the individuals, right, appeared in custody. So if they appeared in custody, they were either handcuffed before they appeared before the judge because you could hear it in the audio, or they were appearing by video, meaning that they were incarcerated in a county jail and they used technology to have them zoom into the court. And very few were actually out on bail. Or I guess not so much, 57%. In terms of deposition, very few got released, so 9%. Most people were still incarcerated, and 71% of the sample got at least some form of cash bail. Others were remanded. What's really interesting about this court is that there's one presiding judge, but when she does go on vacation or is not somehow present, you have other judges that will hear first appearance cases. And I'll talk about the differences between the judges in a bit. So in terms of typologies of openings and closings, we were able to identify five openings. So the first one is information. So the judge will directly interact with the defendant and let them know something about their case. And that could be whether the case is being sent to grand jury, they have a right to a probable cause hearing, or if an interpreter is being requested for translation. Other times, the judge will give an order opening. So the judge will verbally indicate to the defendant what they should be doing with their body or what they should be expected to do before they appear before the court. So they'll say something like, come up, come forward, step up. And these were common orders that were seen in openings. Then others would get respectful statements like, good afternoon, how are you? The judges may have apologized to the defendant for mispronouncing their name. So they would say something like, forgive me if I mispronounced your name. It was really interesting. It didn't happen for all the cases. So it's like, so if there was like an Eastern European sounding name, the judge would apologize. But if it was like a Latino sounding name, even if the judge mispronounced it, they wouldn't apologize. So it would be really interesting because in either cases they're mispronounced, but why does one get an apology and one doesn't? And I don't try to draw these conclusions because the data doesn't allow for that. But when you hear them, you feel like there's something there that requires further probing. And then clarification. the judge wanted to know if the person that was appearing before them was actually the person. So they'll say something like, what's your name, Mr. Parker, Ms. Kukovic, counsel your appearance for the record. So typically, if it was a private case, then the judge would not interact directly with the defendant, but rather the counsel, the private counsel. And then finally, caution. So some defendants, the judge would just caution them right off the bat. I just want to remind you that you're now appearing before the court. Anything you say here could be used against you. So now we see variations, right, in openings and closings. Some people get caution, some people get a good morning and niceties, and other people, you know, the judge just wants to know what is their name and whether they're the correct person appearing. Then we identify 4 types of closing statements that characterize the way judges ended a case. So again, we see similar, right, information the judge provides to the defendant. Your family is here, or this is it for now. Your next court date is, your bell is set at. And that's how the judge would end the case. Other times, the judge would give an order. We're free to go. You can step out. You are done. You need to be interviewed by the court staff or have a seat, because they needed to be interviewed to see if they qualify for defense or some kind of, you know, post-trial, pretrial service. Other times they would get respect. So thank you, have a nice day, have a good day. And like I mentioned earlier, sometimes no closing at all. All right, okay. And the judge proceeded with the next case without officially ending, right, the defendant's appearance. And so, as I mentioned, there were 4 judges, right? Oh, I want to go back to a previous. There were 4 judges. Judge M was the presiding judge. And you can see here, for most of the cases, right, she used clarification statements, right? And so when we ran a chi-square test to see if there's variation between the kind of judge and the kind of opening and closing they would receive, we found that to be significant, right? Even though Judge M, we'll call her Marley for a second, used clarification in a majority of the openings, we see similar patterns, 104, we see similar patterns, right, across, in terms of across all 4 judges. The others also varied, like for example, Judge Andy used respect in most of the cases. Judge N, on the other hand, also used clarification similar to Marley. And Judge E, it was a cross between clarification and respect. Now, this is really interesting because we see variation between judges. And again, I don't draw any conclusions, but that we need to look at judging style and how judges deploy language and how they perform power order in the courtroom, because this finding is suggesting that there is a difference in terms of who the judges that the defendant is appearing before. In terms of case closings by judges, again, Marley was the presiding judge, and in most of the cases, she used order, right? Close out the cases. In terms of the others, Judge Andy also used order, and the others used info more so. And so 2 things could be happening here. Because the nature of the case, maybe they need the defendant to comply, and as a result, they need to use maybe more punitive language or language that demands, right, some form of compliance, compared to, let's say, Judge Nixon and E that didn't, you know, felt like they needed to provide information to a defendant so they can know what's going to happen next. So this idea that, you know, the likelihood of a defendant complying could be the reasons why they're getting variations in openings and closings. In terms of key attributes, although I mentioned race earlier, this was a variable we could not, you know, include in the analysis, particularly because it's difficult to identify race through audio recordings, and hearing someone's surname or how they're talking is just not enough, because They could be culturally from a region that speaks that way. So that was really, really difficult to do. So as a result, we looked at variables that the literature previously suggested that would cause some kind of variation. So in terms of gender, right, whether the defendant was male or female did not matter in terms of what kind of opening they would receive, because the chi-square test to examine if there was a difference between the variables was not significant. But is it working? But representation, on the other hand, whether they had a public, private, defender did matter, right? And in those cases, they were more likely to get clarification statements when it was a public defender, right? And that was the case also for public as well. Use of an interpreter was not significant for openings, but it was for closings, which is really interesting. And then same thing for mode of appearance. How they appeared before a court, whether it was video court or out on bail, was also significant in terms of what kind of opening they could receive. And it was either going to be clarification or respect. Now, closings by key attributes, as I mentioned, gender, we didn't find significance, even though the literature suggested that we would, right? Because we know that there are variation or differences in how women and men are treated, or male and female. But hyper-representation, unlike openings, was not significant, but interpreter was. They were more likely to get order statements. And that's really interesting because order or without interpreter was a cross between info and order, but with an interpreter, order statement. And I do think there's a reason for this. I think when individuals are unable to articulate, right, in English, the judge thinks that somehow that they're trying to get over or they're trying to play the judge, you know? And there were scenarios in the actual transcript where an individual went to pretrial, they got interviewed, they were able to articulate, you know, normative things like what is their name, what is their address, because they get to practice that on a regular basis. But then when you get to ask them like more complicated questions, like, you know, about the law or the charge, they might say things like, I don't understand. So the judge was like, didn't you answer the, you know, the pretrial server 5 minutes ago in English? Why don't you understand me, right? And I think that somehow shaped, right, whether they got an order closing. In terms of mode of appearance, we see that it's significant as well in terms of type of appearance and the type of closing that the defendant would get. And so we see it more here, order, right? And that was largely because they were in custody. And I think technology also played a role in how the judge treated the defendant. The technology wasn't always clear cut. So if the defendant couldn't hear the judge and took longer than usual to respond to the judge would get upset and start yelling at the defendant or ordering the defendant to step out. So all this to say, it might not be a personality issue that the judges have, or maybe it is, right? They lose their patience really quickly, even though they're supposed to be patient and dignified and respectful at all times. So obviously the findings offer a typology for studying judicial speech in lower courts. Case openings can be characterized in 5 different ways: caution, clarification, information, respect, and order. During openings, clarification and respect statements by the judge occurred more often than other types of openings. In terms of closings, we see 4 kinds of closings: information, order, respect, and lack of closure. And most of the cases we see a cross between order and information statements that were most common. The 4 judges that heard cases had variations in the way they open and close cases. So chi-square test found that these variations were significant across some variables, but not all. And it also varied in terms of openings and closings, particularly across mode of appearance, legal representation, and use of an interpreter. And these findings, to some extent, do parallel previous findings that reported differential treatment, of course, across these attributes of defendants. In terms of implications for policy and practice, we know that defendants' experiences can vary widely. And that is okay, right? Because we expect that to happen. But the issue, I think, could be that it has implications for public perception and procedural justice. Like someone like me that is of color goes before a court and is listening to this stuff, then I walk away with the idea that the system is not fair. And probably like, you're thinking, well, who cares what you think, right? Who cares how your ideas of justice are shaped? But that could also, right, shape in how I interact with others, the kind of stories I tell around my experiences. And that could also, in many ways, muddy, right, other people's perception. It typically happens even in everyday social interactions. You hear bad feedback about something, and suddenly you're like, oh, well, you know, it's made up, it's fake, it's rigged, or, you know, I know it's against people who look like me. But I don't test directly, right, defendants' perceptions of procedural justice because that's beyond the scope of the paper. These were court transcripts, so I didn't have an opportunity to follow up. But I think future scholars should, right, given that there's a typology now that they could look forward to and they could directly test. And it's also a starting point for researchers to investigate how judicial language may affect perceptions of fairness. Because again, these are trivial things, but I think the trivial things matter, right? If I say good morning to someone and not someone else, or ask, let's say, Vic how his weekend was, but you, it's like, hey, and then I go to my office, you kind of get to understand these differences, and then you start to make assumptions about what these differences, you know, are and why they happen. So it could be that I like Vic more than I like you, right? Or that, you know, I have some kind of preferential treatment, right? And so forth. So there are limitations too. Obviously, typologies of openings and closings may not be emblematic of lower courts. This is a study that occurred in New Jersey, but I think it should be tested elsewhere. Also, there are differences between judges in terms of style. So we saw, obviously, there were differences in how judges open and close cases depending on which judge, right, heard the case. And so I think future research should look at judges' temperament, how they do judging, right, like gender, race, and how that shapes the way we do judging. I know, for example, because I'm a faculty member that commonly gets confused as a student, I have to dress professionally. I have to make sure that, you know, I don't do particular things that could signal or undermine, right, my professionalism. And so maybe that also plays a role in how judges are interacting with defendants. Because these are transcripts, perhaps there was a better way to code them and analyze them. And because I'm too close to the subject, I don't know if that's actually true. So that's why I called in Dr. Vic St. John to lend me a hand with this manuscript to see what else could we be doing with the data that we have. Obviously, a limited number of defendant attributes. I would have loved to have, you know, analyzed race, but that was not possible. Also, how someone looks visually, right? That there's also capital in that. There's research that shows that people who are conventionally good looking get better outcomes or better treatment. And I think that should also be included. Although also other attributes that could motivate differential treatment, religion, for example, Christian versus Muslim and so forth. Skin color could be another interesting attribute to capture as well. In creating typologies between openings and closings, I'm not necessarily creating a value judgment on which one is better, even though I think we can all agree respect is probably a better outcome to have, or getting have a nice day from a judge is probably better. But again, I'm not really creating a value judgment. The idea is that, is it the same and how does it shape, right? How could it shape the courtroom process? At best, I think the model, right, the typology, offers a tool that researchers can employ to study systematically judicial speech in courtrooms, something that's typically overlooked in court research because we might be more, let's say, focused on sentencing outcomes. So avenues for new research. So I'm currently at St. Louis University, and during my first year at St. Louis University, as a result of this project, I designed a systematic protocol that students can take to the courtroom, make observations, and then check off based on this project that was done in New Jersey. So we're looking at typologies of openings and closings. They're all listed. Students get to observe court cases. We go 5 days a week from 12:30 to 3:30 because that's when pretrial hearings are taking place. And students get to check off. They can't talk to each other. So we have more than 2 coders present in the courtroom at all times. and they check off what is it they're observing. Then they scan and return the sheets, and we're creating a database because we'll get to test now in St. Louis, Missouri, in their pretrial court, whether there's a difference in typology. Maybe we'll come across a typology that we haven't initially identified. And then we're now able to, look at variables such as race, because we have two coders. We're able to look at skin color. We're able to look at other attributes, whether the person had some kind of physical injury or whether there was a victim present, and variables that we could not capture within the audio recording. And I know I already said this, but we're able to capture other variables that are omitted from the transcript. And that brings my talk to a close. So I hope you enjoyed it. And I hope you found the talk interesting. Thank you.
I have maybe 2 or 3 questions. I have like so many different thoughts in my head.
I hope I can answer confidently.
Maybe a couple of questions and a suggestion for you. How many judges do you have in this database? 4 judges. So I was just curious. I mean, you have done I-squared analysis, but in terms of just analysis, that could potentially do is run maybe a multinomial logistic or probit regression, but then you have to sort of think about, you have data sort of nested by judges, right? So you have to sort of account for that. But then if you run a multivariate model, then you can explore some interesting things. For instance, the mode of you mentioned online versus in person, right? You can also look at the combination of that with the poverty, the measure of poverty that they have, right? Right. So and then there are other combinations that you could potentially. I don't know whether you have enough statistical power, but I think that will allow you to sort of test a number of different things that you can't really test just doing simple chi-square analysis. The other question I had was, can you link it with outcomes, right? The case outcomes. I think that would be pretty.
I would love to,
right?
but not everyone. So we're looking at 10 audio recordings. Not everyone had enough. Yeah, but I think with first appearances, typically they don't end with that first appearance. There'll be subsequent dates. And with a lot of even now we're doing in-court observations, it's difficult to kind of follow around the individual, because let's say they have a court case today and my student and I were present, they might appear again on a day that we are not present. So each of the student picks a day. So they usually go twice a week. So we have a Monday, Wednesday crew, and then a Tuesday, Thursday crew, and then a Friday crew that could only commit one day to the project. And so sometimes, right, when we're collecting the data and building the database, we're able to still trace them, but I'm afraid that won't be able to take place for every single case. But it's something I'm definitely paying attention to, because I think outcomes are really important.
Yeah, I mean, if you could talk to the judge and see if you can get access to the administrative data, if you can link them, I think then I think you'll be able to test, like whether there's different types of use of language, how they are related to outcomes.
I see a hand over there.
Thank you so much. Very interested in the research that you do. A question that I had when you were talking about the opening and the closing, did you guys factor in like the day where the hearing goes? When you mentioned like the opening is good morning, hello, like the judge is very human in himself or her. And most of the time it varies depending on the day and the case that comes before and after.
Yeah.
Like the judge viewed as a day or time. I know that could be difficult to think, but I was thinking of the time of the day.
Yeah.
It's 10.
Yes.
Yes. So it could be a factor or something.
Yeah.
Yeah.
So we couldn't do it here because only 10 transcripts, but in court, we find that judges are a lot nicer after lunch. leading up to lunch, they get cranky. You're kind of screwed if you're going before the judge right before lunchtime. Because at that point, there's decision fatigue, right? And this is pretty much talked about in the literature where judges get cranky or they're more likely to give harsher outcomes or remand you or not give you a bond hearing and so forth. Also, because again, small sample, again, we only did 10 transcripts, but we had, in a day, 40 defendants could be heard. And that's how we got to the 294. But I think it's a wonderful idea, right? Checking to see if judges are a little nicer at the beginning, or maybe they're not, because Monday, I feel like everyone is always beefing with Monday. Monday's a bad day of the week. Everyone has a case on the Mondays, right? Maybe it's not Monday, but maybe like Monday, midweek, and then end of the week. I think we get happier closer to the end of the week, and maybe that could shape outcomes somehow. Yeah, there are various ways to test these things, and everything that you just mentioned, it's documented in the literature.
Have you thought about disseminating your findings to judges and the nuances of doing that? Because like, obviously, like your meaner before lunch isn't always going to be well received. So.
Yeah, so the judges are, so because we're doing systematic social observations, we're not allowed to talk because that then shapes how you're observing. The judges do talk to us. They're very friendly. So I feel like in the beginning when we showed up in court, they were like, what are you doing here? Like, why are you here? Why are you coming every day, right? Because the idea of being watched and evaluated, I think a lot of people don't feel comfortable with. But then when you become a familiar face and you're friendly, then judges interact with you. They'll ask questions. They'll engage you in small talk. So no, I haven't told them that they're usually crankier before lunch. And I don't know how I would go on about doing that. Maybe we'll like put it in writing in like a paper and say, oh, this is what we found when we were observing your court. What's really interesting about the courts we're observing now, there's only one presiding judge, right? Whereas the one in New Jersey, there were 4. There was a main one, and then there were others who took over when that judge was not able to hear cases.
Those other judges have their own court. I'm curious whether the judges acted differently when they were in somebody else's court versus when they were in their own court.
Yeah.
Which you couldn't observe, but you had the 3 who were not in their own court.
So Friday's typically that day where some, fill-in judge will sit in, and yeah, there's immense variation. So we have this judge, extremely theatrical, like berating the prosecutor, berating the defense for not having their paperwork organized. And that typically doesn't happen in other courtrooms because the judge wants to indicate to the defendant that everything's organized, assembly line justice. But in this case, I felt like all the rules were kind of, somehow halted for the day. So yes, judging style is very much an issue. And not, depending on what judge you get, defendants know that if they're appearing before X judge, they might get a more lenient outcome. Whereas if they're appearing before Y judge, they know that they're going to not go home that day or they won't get bond that day. And even us as courtroom observers, we know what the judge will decide based on having observed that judge since last year, because we've kind of know their judging style.
Corey's next in the queue, and then by show of hands, that's how we'll kind of queue people on questions. Corey.
Thank you so much for your work and presenting it today. So when I listen to you and I look at what you found here, what's sitting to me is the respect. And that respect is that's the variable that I'm wondering if you might sit on with us for a little bit.
Yeah.
For 2 reasons. One, because respect is actually noted in the expectation that judges are to show respect. So number 1, how is respect operationalized? How do you operationalize it? And what are the variables that impact respect is shown? And then what are the implications of that? And I know you talk about it. We're not going to do a value judgment, but a value has already been placed, right? So you
Title of the talk, insert
right?
respect.
So you can't do that. So I want to push you a little bit on
Yeah.
it because that's actually where I think the meat is. When is respect given? How is that operationalized? And what are the implications of that?
Yeah, thank you for that question. So, as I said, as a doctoral student, when I went to court, I was very sensitive to the idea of respect, right? This idea that just because there's a power imbalance, that it doesn't give someone the right to treat you differently or talk down to you, berate you, or belittle you. And so when I went to court, it was very difficult for me to capture respect, but in the transcripts, when I saw the variation, I was like, this doesn't feel respectful. So first it was like an innate kind of like reaction, right? Like, this doesn't feel respectful, this doesn't feel fair. So then looking at the literature, the procedural justice literature, it's about uniformity, it's about kindness, it's about empathy. It's about how we, go out of our way to see how someone is doing, or we wish them a good day, right? Those were indicators of respect. And the other issue is that because it's assembly line justice, it's very difficult to look or understand respect outside of this assembly line, because everything's kind of uniform, the judge is following the script. And within these two open categories, right, that's not codified by law and policy, there's variation, right? And that's really what informed my analysis. Like, why is there variation? And why is it that some defendants get X treatment and they get Y treatment, right? And I tried looking at different types of variables, and, apparently there is significance in how, judges open and close based on these variables. But this is something I'm still really fleshing out, right? Like, how do I define respect better, right? And then how do I think about respect outside of terms like have a good day, right? The niceties, right? And so this is something that I'm currently fleshing out, and I want to continue thinking about, because I think it's, one, important, and two, if we're thinking about creating a fair world or a just system, then we also need to make sure that our citizens, right, for which we are representing, we are making sure justice is met, or that we're representing their beliefs, that they also feel that this is what the expectation is, or this is what represents, right, who we put in power and who we ask to represent us. So thank you for pushing me on this. I feel like it's really important to figure out what constitutes respect. Because I do think it varies also from culture, geographic location, courtroom, and so forth.
Just a real quick follow-up. Does the code of conduct give any indications of what that is? Because it's respect, they say that they expect.
I mean, they give you,
Or do they say this is what this is?
they don't define what they mean by courteous. They don't define what they mean by patient, right? I mean, there will be things that judges are expected to do, but so they won't say that judges are not allowed to yell at defendants, because that would be a sign of disrespect. So it's really tricky, and I think law is part of the problem.
Yeah, so just a two-finger on what Corey was just talking about. I do think when you get done with your data collection in St. Louis, you will have an interesting regional comparison, right? So I was just thinking about Midwest nice versus New Jersey, East Coast. I have no disrespect towards New Jersey, but different from Midwest nice, let me put it that way. But my main question was actually about charges as a variable. And I was just wondering how you might think about the interaction between these different responses based on the charges that the person is actually accused of, right? So wondering if it affects, I guess, three parts, right? Does it affect openings? Does it affect closings? Does it affect both? And so I'll just leave it at that.
Yeah, so for some defendants, we do have charges, and we started, coding for the top charge.
Yeah.
And some no, because if you had a private defender, you get to have
To not
the
have to.
charges waived, the reading of the charges waived. And so it was kind of one of those messy variables where we felt like we couldn't observe it for everyone. It would be kind of difficult to run an analysis and make conclusions. But now that we're actually observing, we get to actually hear the charge, unless, again, it's waived. But typically what we do is we'll go outside and see, who the person is, and we'll look it up and see what the charge is.
Well, that's what I was gonna think about for this paper, right? Does it make sense to take time either with an undergraduate research assistant or not? To like go back and look at the charges, right? That were actually, because even if the reading is waived,
Yeah.
right? They're still part of the record that you could go back and like do some matching for those 10 days of cases. Is that accurate?
Yeah, so for this one, it was tricky because the IRB didn't want us.
Ah, gotcha.
So that's the other barrier,
That's an
right?
IRB, yeah.
The IRB doesn't want you to go back and match people. They also want it, even though this is public record.
Yeah.
when you go to access or request transcripts, they're not always readily giving them up. You have to usually, again, you're entitled to it because you're the public. You can request it, but the law clerk's office will kind of push back. They'll give you a runaround. You have to give, an explanation for why you want it. You can't just say you're the public and you're entitled to that, right? You have to have a very, very, very well thought out reason, and they can deny you. So it's public, but it's not public, right? And then the IRB didn't want us to look people up. They also said things like, we don't want you using, even though it's public information, we don't want you using people's real names. You have to make sure you give them pseudonyms, make sure you're not making, even though these transcripts are technically public, you can't make them publicly available because they have people's addresses, their date of birth, where they were arrested, and all their history of a criminal record. So there's a lot of restrictions, and so that also shaped why the analysis appears thin. But I think we're going somewhere. I think it could evolve into something beyond what I have imagined. So I'm just gonna allow the research and light to go on.
Yeah, off of Melissa's point, I was wondering if you haven't already, just controlling for weather and time of day, of course, because I think to some degree, right, if it's pouring down or, it snowed a foot the day before, I think how that initial interaction might occur could have some influence in that regard. The Army does a good thing before you do a training exercise. If you're being evaluated, you have to denote the weather because it does impact morale of how you operate or interact with people.
Yeah, in the criminological literature, we see that violence, right, spikes during the summer months, right? So it would be interesting to see, if there's an impact on judges' interaction. You should do it. I can't do it all.
There's a hand over there, and you're creating a database, right? So that can be something that can be used. And assuming the guardrails aren't just, because you have audio transcripts, which come with certain stipulations, but now you're doing public observations and collecting it yourself. There's a lot more leeway there. But I do want to point to this gentleman over here.
Thank you, by the way, that's super interesting. I wonder if you've done any work to see if there's any consistency across the typologies. Like if you get a respectful opening, are you more likely to get a respectful closing as well? Because that would kind of suggest that if you don't find that the case, if there's something about the interaction itself that typically changes what the outcome is.
So no, I haven't. So from my knowledge, this is the only study that looks like, so we're kind of the pioneers of typologizing the openings and closing because everyone else thinks they're trivial. Like some of the reviews I get after sending the article out twice, is like, why do we care? So what? It doesn't substantively tell us anything about the law or case outcomes. And I'm like, no, wait a minute. People pay attention to these things. They're not as trivial as we think they are.
I think a good point, and then I'll pass it over to Greg, who had his
The microaggression, but case openings and closings is what I'm calling them.
You have it.
Oh, yeah, so thanks for your talk. It was good to meet you earlier today. I had more of a sort of a theoretical question related to typology and kind of like how you sort of understand what a typology sort of is and why, and you talked about this a bit at the end, kind of why a typology for this. And then going back to a point that Corey was just making here, about kind of respect as a variable. I was thinking about the code of conduct that you were sort of describing. And I wondered if the code of conduct could be a starting point for connecting its different kinds of dimensions to kind of some theoretical explanation about like what each individual component entails. So like bias as an example, there's a big literature on that potentially could be leveraged for providing a more substantive understanding of what that kind of constitutes in the context of this kind of larger discussion that you're having in respect to. I mean, there is a literature on that as well. And so I really would love to hear more about the
Yeah,
typology part.
yeah,
of-
yeah. So because my training is in criminology and criminal justice, we went with procedural justice, right? Because tried and true, I think most criminologists understand procedural justice, ideas about fairness, ideas about uniform treatment, and so forth. But I'm always open to literature outside of criminology and criminal justice to see what else is out there in terms of respect, right? And I also think because this work is to an extent interdisciplinary, you kind of get lost in the literature fog, right? And the maze. And I think at some point, in order to finish, you have to make several executive decisions. Right? We're going with procedural justice. It's a programmatic requirement. It's not my life's work. I have a dissertation to finish, right, on sex work and religion. But the cool thing is now I have time on my hands and I get to come back and I get to get suggestions like this. And I would love if you could, link me or bring to my attention other types of literature that you think I could, incorporate. In terms of typologies and types, to me, I used to take terms interchangeably, typologies and types, without necessarily thinking about theory, right? But if there is a theoretical literature around this type of categorization, then I also welcome that too, because I do think it could really inform the analysis and perhaps get the paper housed. I would really love that. I wish I had the answer to everything, but the more I evolve in my career, I realize that it's okay not to have all that.
That's true.
And being okay with admitting that.
So one question I had, well, this was super fascinating, so
Yeah.
thank you so much.
Yeah.
So I know you mentioned looking at the attributes of the client now that you're doing the influence observation. And I think you also mentioned potentially looking at the attributes of the judges themselves. Like, I'm wondering if women judges across the board tend to give a certain type of language.
Yeah.
But I'm also curious if you're looking at the interaction, between the judge's attributes and the defendant's attributes, and whether those have an influence on the type of opening or closing statement.
So right now, we're not capturing characteristics around judges' attitudes, but characteristics, I'm focusing more so on the defendants. And one of the things that we do account for is whether the defendant appeared upset, whether the defendant was crying, whether the defendant was trying to directly talk to the judge or complaining about something, right? Complaining about justice, complaining about, the police mistreating them or someone's lying. So we do capture that. But because there are two courtrooms where the judges are listening to the court cases. One of them is an older judge, more seasoned, and one of them is a younger judge. And she took her father's role in terms of the courtroom. So her father used to be the presiding judge. And there's a clear difference. So the younger judge is like a textbook case of procedural justice. She makes sure that the defendants know why they're appearing before the court, what the judge is, whether they understand what they did wrong, whether they understand the next steps, and whether they understand they have to appear before the court. Otherwise, a warrant will be set out for their arrest. Whereas a seasoned judge doesn't go through, the procedural aspects. She doesn't make sure that the individual understands what they've done, understands what the expectations are, understands what the outcome will be in the event that they don't comply. And that's an example of judging style, right? In terms of their personalities, I like to think they're similar, right? They're not necessarily yelling at the judges or, it's kind of, again, scripted. But one tries to be efficient and the other one, her cases can go on for hours. And the law clerks start complaining we're still here. So it's really interesting. But I think judges' attributes is something definitely people should really look into carefully. Personality traits, what their background is, how they do judging. We often talk about doing gender. I feel like someone should write a paper on doing judging.
Questions, show of hands?
One quick follow-up just to what you're talking about here. I do think the judge's attributes are relevant. I'm wondering about the defendant's attributes in a very specific sense that I think you can capture in the new data, not in this data, which is gender and racial counter-stereotypic behavior. So certainly there's a literature on gender counter-stereotypic behavior on defendants and whether or not, particularly at sentencing, right? So it's the other end of what you're studying, but it's making me think of whether or not that might be relevant at opening and closing as well with regard to your typology, right? So if you, not just gender stereotypic and counter stereotypic behavior, but also racial stereotypic and counter stereotypic behavior, right? So if it's someone who is perceptually Hispanic or Asian American and they speak proper English, right? Something like that, it's presumably counter stereotypic, right? Does that then lead to greater respect versus an order decision? Or is the expectation that a Black or a brown individual is going to be more upset, more argumentative, right? Lead to the kinds of judging behavior. So I'm just wondering if those are things that you might be able to capture in this new data or not.
We might, so like when race comes into question, so students are often, talking about, is this person perceived, right,
Right.
Asian? Is this
Right.
person Latino, but they don't look Latino?
Right.
So these types of conversations do come up a lot, but their last surname is Latino, right? I don't know, this person doesn't appear Black, but they have a Black sounding name according to my students. So we have these types of conversations, and that's why I wanted to put more than one coder in the courtroom, because if one person is doing it, then our perceptions, right, our conditioning around race, ethnicity, gender is going to shape how we're marking the observation photo. Whereas if there's more than one observer in the courtroom, then it creates a dialogue and some questioning around what are we observing and are we observing the same things? So I think, yeah, it's very much possible.
Yeah.
But the other thing that's interesting is that defendants typically don't do a lot of talking. And when they do, the judge reminds them almost immediately that they are to stay quiet. And if they do wish to talk, then they have to do so through their lawyer. But that's not always the case for every defendant. So I think there's something else there, right? Capital, as we were talking about earlier, or something that signals to the judge, okay, this defendant is not playing by the normative rules because they know something, right? Or they know they can behave out of turn because they're aware of some kind of, loophole, or they're aware that they can behave this way and the judge cannot, react in an adverse fashion. And I think it's really interesting. We just have to think about how to capture it carefully and whether it could be captured in this context. Because we have a protocol that's already like really, really long. I'm trying to capture immediately the things that I felt insecure about when I was doing this study. And so the protocol that we're deploying now essentially covers all of those insecurities. So we can straighten the paper. Someone else had their hand.
Sorry, this is just a really simple question. How did you deal with instances where a judge might have said something like, please step forward, how are you doing today? Like, were there instances where there were multiple forms of like an opener in one go?
So here's what's really interesting about St. Louis. The defendants don't actually appear before the judge. They're all shackled to the bench. And you have to pay attention as an observer to figure out which defendant the judge is talking to. Whereas in New York and New Jersey, that's unacceptable. I think the public would go absolutely nuts and strike. But in St. Louis, for whatever reason, it's tolerated that defendants come in shackles, they have a seat, right? And the judge will sometimes look down, address the defendant, not make eye contact. And so these are the things that have been troubling, right? Because one, they shouldn't be happening. And two, how does the judge know which defendant they're addressing? And then how does that shape the defendant's understanding of how they're being treated, not necessarily as an individual, right? But someone that's a part of a group and being addressed as a group. So it could create a lot of confusion around what the next step should be, the extent to which they should be, complying. And the judge doesn't necessarily, right, double check that they understood what their next steps are. So there is variation. In this particular context, particularly St. Louis, it depends really on the judge. So the judge on Friday is very friendly, the one that berates the prosecutors and the defense. He's typically very friendly. So he'll say something like, I'm going to let you out, but I want you to know that, if you get into trouble again, it's my butt and it's yours, right? So you see a little bit more like impersonal, more like personalized interactions, personalized closings, right? But you don't see that during the week, right? In terms of judges taking that extra step to make sure that their defendants understand or good afternoon or have a nice day. And I guess maybe it's not good to tell someone who's in handcuffs to have a nice day, because we know they're not going to have a nice day because they're incarcerated. I don't know what's shaping it, but yeah, we do pay attention to a lot of these interactions, because on the sheet, we have the typologies and students do check off, you know, which ones they're listening to that's unprompted.
A point of clarification, I think one of the components you were asking was also if there are cases where both two types of categories pop up, like both the respect and.
No, so the categories are exhaustive, and we really tested them to make sure there was no hybridity, you know, they either fall into one or the other.
Hmm.
Yeah. Yeah. Otherwise, it creates a lot of like confusion as to what is, and so it has to be unprompted, so it's the first thing that's communicated, and it needs to be mutually exclusive.
Just so you, so I thought the question was that in one sort of the judge could in that opening say two things. Come to the bench and have a good day, or something like that, or good morning. Those would fall, according to what I saw, two different categories. So you're saying you did not code them for both?
So if there is an interaction and the defendant says, you know, something else and the judge says, have a nice day, then it would be the first unprompted, right,
Or,
one
yeah.
that we code for. Because something else prompted to have a nice day.
Oh, no, I meant, let's say, for example, it said, good morning. Approach the bench, right? That was all the same. It was, they just said two different sort of phrases.
Yeah.
So in that case, did you code? I thought that was.
It would then be
Twice.
respect. If it's unprompted, we would code it as respect.
You would
like-
code the whole
Yeah,
interaction.
as respect. But if it's something that was prompted, then it would count as respect. Because it was something that created that outcome. So I'm
Also
trying to
first.
create, yeah. Go on.
I was gonna say, so also the first piece, like whatever kind of comes first.
Yeah. But it has to be unprompted.
I heard it.
No, I think I was just gonna say, I think we're at time.
Oh, we're at
but-
Order.
Thank you all for this. This was great.